Okay, parole evidence rule. What is the parole evidence rule?
Oral evidence rule attorney is when an agreement is reduced into writing, the writing is presumed to contain all terms. Extrinsic evidence cannot alter the written agreement. Meaning po, after the document has been made by the parties attorney, the successor po, they cannot alter the agreement between the party who made the documents po.
So basically, parole evidence rule provides that when an agreement is reduced into writing, the writing is presumed to contain all terms and conditions. Extrinsic evidence or evidence al unde cannot alter the written agreement. Okay? So what is the purpose of this rule? It is to protect the integrity of written contracts. The rule protects written agreements from alteration by oral testimony. But this rule admits certain exceptions. So a party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts in issue in a verified pleading. Take note ha, I emphasis on it must be put in issue in a verified pleading. So meaning, there must be, so when you say verified pleading, what does that mean? Where do you raise the exception to the parole evidence rule?
Hello po, attorney. It means, attorney, when you file the complaint or the pleading, and or when the respondent filed an answer to the complaint against him po.
Is a motion a pleading?
No po, attorney. Motion is not a pleading po.
Complaint or answer, those are initiatory pleading. Initiatory and responsive pleading. Right?
Yes po.
When you say verified pleading, what does that mean? So when you say verified pleading, so you only answer what are considered pleadings, complaints, answers, but not motions, right? But when you say verified pleading, what does that mean?
It means po, attorney, that the one who filed personally prepared and have the pleading has an acknowledgement and properly notarized po.
Ba yung natutunan ninyo sa CIVPRO? When you say verified pleading? What must be attached to the complaint or answer?
When you say verified pleading po, attorney, there must be a verification po on the sworn statement that the pleading is based on personal knowledge or authentic records po. Meron po
There must be an attached verification.
Yes po, the verification po.
If there is no verification attached, then the pleading is not deemed verified. Always remember that. So take note, for you to claim exception to the parole evidence rule, it must be raised in issue, it must be put in issue, the exception must be put in issue in a verified pleading. And for it to be considered, for a pleading to be considered verified, you have to attach a verification. Without that verification, you only have a pleading. And you are not compliant with that requirement. That it must be, you have to put it in issue in a verified pleading. If you raised it in a motion, that's not allowed. You cannot claim exception if you only raised it in a motion. Why? Because a motion is not a pleading. So always remember, to claim exception to the parole evidence, the exception must be put in issue in a verified pleading. So what must be raised? So what are the exceptions to the parole evidence rule? What must be raised? What are the exceptions to the parole evidence rule that must be put in issue in a verified pleading?
That there's an intrinsic ambiguity, mistake, or imperfection in the written agreement po.
So when you say intrinsic ambiguity, what does that mean?
That there's a that there's a big or double that there's a big or when we say intrinsic po, it is in the document itself that there's a that the content of the contract or the document po, there's a ambiguity or that there's a when we say intrinsic ambiguity, it is in a document itself that there's a big or hidden intention when the contract was made for.
How is that different from extrinsic ambiguity?
When we say extrinsic po, attorney, it is outside of the contract itself, outside of the document.
Are you sure? Miss Larsana, do you agree with your classmate?
On some parts, but I would try to add.
Do you agree with him?
No po, attorney. Intrinsic ambiguity po, as we referred to here, it is when the language of the written agreement is actually clear or clear on its face, but there will be uncertainty when it will be already applied to the actual facts involved. Like if a contract would state on its face that you are selling a certain property on an address to a seller, but it turns out that the seller owns two houses on the said address, then there will arise an intrinsic ambiguity because the court will not know which house was or which property or like a house would be the subject of the said sale. So that is an example of intrinsic ambiguity. While the extrinsic ambiguity is actually obvious on its face by just reading the document that it is incomplete or it is indeed vague, attorney.
Papa, how did the water go there and it's getting almost bigger and bigger and bigger?
Sa aircon.
Hmm?
Sa aircon. Later na, we will talk later. I will study.
Why is the aircon that water?
Suppose-
inside?
Close.
Hmm?
Close.
Suppose the last will and testament contains the following provision. I leave all my properties to the 3 children of one. And it turned out one has 5 children. In the last will and testament, there was a provision stating that the testator is leaving his entire estate to 3 children of one. But it turned out that one has 5 children. Can you claim exception to parole evidence? Can you present evidence aliunde?
Yes, attorney.
To clarify who are the recipient of the estate.
Yes, attorney. Because it appears from such facts that there is an intrinsic ambiguity in such case, attorney. And in such intrinsic ambiguity, parole evidence is allowed for. So, to
What kind
clarify.
of ambiguity exists in such scenario?
It would be an intrinsic ambiguity, attorney.
Why is that?
Because from the facts of the scenario, it was stated that there are that the will would be left to 3 children, but in actuality or in actual
No, stop right there. If you're going to read the provisions found in the will, I leave my entire estate to the 3 children of one. Yun yung nasa provision, right? I leave my entire, yun yung nakalagay sa will. I leave my entire estate to the 3 children of one. Is that provision ambiguous? Yes or no? Is there ambiguity?
in that case, no po, attorney.
Who says that provision is ambiguous? Mr. Sarmiento, you were nodding your head. Do you think the provision is ambiguous? I leave my entire estate to the 3 children of one.
As to the very face po of the will, no po, attorney. But for...
No, is it exactly? I was asking you that provision alone, is it ambiguous? That there exists an ambiguity?
No po, attorney.
So it's not ambiguous, right? It's clear. Kasi the entire estate will be given to the 3 children of one. It's very clear kung kanino mapupunta yung entire estate. 3 children of one. There is no ambiguity to that provision. However, the ambiguity will arise when you find out that one is in fact, when one has in fact 5 children and not 3. Now it becomes ambiguous, right? Why? Kasi kanino mo ibibigay? 5 yung anak ni Juan. Sino yung 3 na maghahati-hati sa estate, right? So the ambiguity will only arise if you consider extraneous facts that are not present in the will. Yun yung ibig sabihin ng intrinsic ambiguity. A mere reading of the provision in the will or in the contract, it's not ambiguous at all. There is no ambiguity. It's clear. However, due to some extraneous circumstance, that provision becomes ambiguous. Then you have an intrinsic ambiguity. And an intrinsic ambiguity is one of the exceptions to the parole evidence rule. Being an exception to the parole evidence rule, if you put that in issue to a verified pleading, you are allowed to present evidence aliunde or extrinsic evidence to clarify the ambiguity arising from the provision. Yun yung ibig sabihin ng exception to the parole evidence rule. What is considered an extrinsic evidence? Suppose ang nakalagay sa will is, I leave my entire estate to 3 of the 5 children of one. I leave my entire estate to 3 of the 5 children of one. Period. Now, you read the provision found in the will. I leave my entire estate to 3 of the 5 children of one. Is it ambiguous? Is the provision ambiguous? Mr. Sarmiento, is the provision ambiguous?
Yes po.
Why? What is the
Since,
ambiguity?
It is now extrinsic ambiguity po.
Why?
Because by mere reading po, attorney, it will the ambiguity po will be revealed po, attorney.
Okay, you know na from a mere reading of the provision, you know it's ambiguous. Why? Because you don't know sino sa 3 lima, right? Kasi alam mo na 5 yung anak ni Juan, pero ang binibigyan niya lang is 3 without specifically naming those 3 children. You get it? So from a mere reading of the provision, you know that it is already ambiguous kasi you don't know who are those 3 children out of the 5 children of one. Since you now have an extrinsic ambiguity, is that an exception to the parole evidence rule? Will you be allowed to present evidence aliunde to clarify the ambiguity or to cure the ambiguity? Mr. Sarmiento, are you allowed?
No po, attorney. Since
Why
it is an extrinsic ambiguity po, attorney. So you cannot claim the first ground po, attorney.
Okay. So this is my issue with the rules of court vis-a-vis the provision in succession law. Are you done with succession law? I think it's 827 or 829 of the civil code. Kasi if you read 827 or 829, if there is ambiguity in the will, whether it is extrinsic or intrinsic, all kinds of evidence are allowed to cure the ambiguity. Yet, the rules of court only says that intrinsic ambiguity is the only exception to the parole evidence rule. It does not include extrinsic evidence. It does not include extrinsic ambiguity. So in that sense, there is a conflict between the civil code and the rules of court insofar as whether or not evidence aliunde is allowed to cure extrinsic ambiguity. Kasi under the rules of court, if there is an extrinsic ambiguity, evidence aliunde is not allowed. It's not an exception to the parole evidence rule. But if you read the provision on civil code, if there is ambiguity found in the will, whether it is extrinsic or intrinsic, evidence aliunde, all types of evidence are allowed to cure the ambiguity. Okay, so an intrinsic ambiguity, mistake, or imperfection in the written agreement is one of the exceptions to parole evidence rule. Another exception to parole evidence rule is when there is a failure of the written agreement to express the true intent and agreement of the parties thereto. In fact, this may be subject of a reformation case. Diba? You may file an action for reformation. And then, another exception to the parole evidence rule, if the issue is the validity of the written agreement. And lastly, if the issue is the existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. Okay? So these are the exceptions to parole evidence. So meaning, a party may present evidence aliunde to modify, explain, or add to the terms of the written agreement under these 4 circumstances. Okay, so example of the application of parole evidence rule. Suppose you have a contract of sale and the contract of sale states that the purchase price is 500,000 pesos. The party cannot later on testify in court and claim that we actually agreed that the purchase price would be 700,000 pesos. You have to raise an objection to this. What will be your ground? Parole evidence rule. Okay? So kapag nag-testify kapag nag-testify dito suppose si seller nag-testify, sabi niya, actually, the buyer and I agreed that the purchase price would be 700,000 pesos. As the counsel of the buyer, what are you going to do? If you heard the seller testifying to this effect, you have to raise your objection. You have to object. And what will be your objection? What will be your objection? What will be your objection?
Objection.
How are you going?
Testimonies.
Okay. So you have a contract, diba? You have a contract of sale which states that the purchase price is 500,000 pesos. Now the seller goes to court and testify. Actually, Your Honor, the buyer and I agreed that the purchase price is not 500,000 pesos but 700,000. O anong gagawin ninyo? Suppose you were the counsel of the buyer. What are you gonna do? If you heard the seller testifying, Your Honor, actually, the buyer and I agreed that the purchase price is not 500,000 but 700,000. What are you gonna do? Pababayaan ninyo? You're going to object, right? You're going to pose an objection. You're going to raise an objection. On what ground? So, paano kayo mag-object? Objection, Your Honor. O, paano kayo ano yung sasabihin objection, Your Honor, o tatanungin ni Judge, on what ground, counsel?
Attorney, under the parole evidence rule, the testimony is inadmissible under the parole evidence rule because the testimony of one of the party in the contract that the amount is different is not written in the contract itself.
So, it violates the parole evidence rule. So, ano sasabihin ni opposing counsel? What do you think? Nag-raise ng objection. Yung lawyer ni buyer saying na, Your Honor, that is in violation of the parole evidence rule. So, ano yung magiging counter-argument ni lawyer ni seller?
That attorney that there is a mistake in the or there is a typo error or mistake in the execution.
You're going to claim na typographical?
Mistake po or imperfection po.
Eto, diba? A party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts in issue in a verified pleading. So you have to inform the part that, in fact, Your Honor, that is one of our claims in our verified complaint. You get it? Kasi kapag if the seller was able to put in issue in the verified complaint that there was, magkikleim siya dito kung ano yung mistake, 1, 2, 3, or 4, kung saan siya magpo-fall. Definitely number 2, the failure of the written agreement to express the true intent and agreement of the parties. Then, if the opposing counsel will say, Your Honor, we have put that in issue in our verified complaint that the contract of sale failed to state the true agreement of the parties, then the judge will allow the testimony of the seller. You get it? Kasi you have to claim exception to the parole evidence. Kasi the one is claiming parole evidence rule is applicable. Hence, the testimony of the seller is inadmissible. So, ano yung magiging counter-argument ng lawyer ni seller? Your Honor, it falls under one of the exceptions because we put that in issue in our verified complaint. And there was a failure in the agreement between the parties that the contract, it failed to state the real agreement of the parties insofar as the purchase price is concerned. That's how you do it. That's how you claim exception to the parole evidence rule. Kasi kung hindi mo yun i-erase, kung hindi mo yun ima-manifest kay judge, the judge will sustain the objection. And if the objection is sustained, the testimony of the seller will be stricken out of record. I would assume that you are now familiarizing yourselves on how a trial is conducted in court. Kasi diba this is for your instead of written midterm exam, you'll have a mock trial, right? So dapat you should know by now how to properly raise an objection. And if you are the opposing counsel, how to counter that objection. Kasi hindi mo pababayaan yung client mo. Kasi kapag nasustain yung objection, the testimony of your client will be stricken off record. It won't form part of the record. And you don't want that. That's why you want to claim exception to the parole evidence rule. And how do you do that? You manifest before the court that you have put that in issue in your verified complaint. Since si seller yung nagsusue, or if you are the defendant, then you have put that in issue in your verified answer. Okay guys, let's stop here and then let's continue our discussion on testimonial evidence. Okay? Do you have any questions? I'm going to update the PowerPoint presentation and then we'll send the updated version to Miss De Vera. Okay? Okay guys, thank you and have a good night.
Thank you po, attorney.
Thank you po, attorney.